Lordship, I beg to mention of today's list, Lordship, item number 9, Lordship.
9.
Yes, Lordship.
Hearing.
Yes, Lordship.
What happened?
Lordship is not there, Lordship. He is out of station, Lordship.
Okay, when he'll come back?
Lordship, by tomorrow.
Okay, we'll see and we'll adjourn. You no need to stay for you, huh? Yes.
Lordship, beg to pray for listing of an IA for bail.
Bail?
Yes, Lordship.
Shall you be devoted?
Right, Lordship.
Maybe list for episode. I don't know one.
Oxo, no? This criminal appeal from jail is directed against a judgment and order dated 8/12/2023, passed by the Court of Learned Special Judge within bracket POXO, Tinsukia.
I have objection to the bail application.
Let it be in the next week then with the affidavit and record. Heard Mr. P.J. Soikia, learned counsel for the applicant appellant, and MS A. Begum, learned additional public prosecutor for the opposite party number 1, State of Assam. Mr. Soikia, learned counsel for the applicant appellant, has submitted that he has received the copy of the objection
Yes.
filed by the state yesterday.
Today, right now.
Only today. Full stop. As the copy of the state objection filed by the state is not tagged with the case record, stop, the office to list the case in the next week with the objection stated to have been filed by the state, tagged with the case record.
All right.
I don't know 6.
May please, your lordship.
Anybody appearing for
Lordship,
respond number
nobody is
2?
appearing, but we have already taken steps, your lordship. So
Service is complete. On the last day itself,
Lordship.
we have treated service of notice upon the respond number 2 complete. We waited for appearance.
Lordship.
Since there is none, we can.
302 and 364, lordship. Kidnap and murder,
Okay. Judgment is annexed.
lordship.
Heard MS D. Borpujari, legal aid counsel,
Lordship.
learned legal aid counsel for the applicant, and MS B. Bhuya, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty, learned counsel for the opposite party number 1, opposite party, State of Assam. Full stop. The instant application is preferred under Section 5 of the Limitation Act 1963, seeking condonation of delay of 54 days on the part of the applicant in preferring the accompanying appeal against a judgment and order dated 21/3/2024, passed by the learned Sessions Judge, Jorhat, Assam, in Sessions case number 85 within bracket Z-D bracket close stroke 2019. Close stop. By the judgment and order dated 23/1/2024, the applicant appellant has been convicted for the offenses under section 302, Indian Penal Code, and section 364, IPC. First of for the offense under section 302 IPC, the applicant appellant has been sentenced to undergo rigorous imprisonment for life and to pay fine of rupees 100, with default stipulation, full stop. For the offense under section 364 IPC, the applicant appellant has been sentenced to undergo rigorous imprisonment for 6 years and to pay fine of rupees 1,000, with default stipulation. Full stop. The sentences are ordered to run consecutively or concurrently? Concurrently or concurrently?
Concurrently.
Full stop. The appellant in paragraph
9, 10,
8,
8, 9 and 10 Lordship.
8, 9 and 10 of the instant application have delineated the regions for the delay of 54 days, which occurred in preferring the connected appeal under section 374. 2, CRPC. Full stop. We have gone through the statements and amendments made in paragraph in the instant application, more particularly, paragraph number 8, 9, and 10, wherein the reasons for the delay of 54 days has been explained by the applicant appellant. Full stop. M.S. Puya, learned additional public prosecutor appearing for the state, has submitted that since the offenses for which the applicant appellant has been convicted, are serious in nature, and imprisonment, sentence of imprisonment for life has been passed, the accompanying appeal is required to be heard on merits. Full stop. We have gone through, having gone through the statement and environments made in the instant interlocutory application, more particularly in paragraph so and so thereof, we are of the view that the applicant appellant has been able to show sufficient cause regarding the delay of 54 days in preparing the accompanying appeal. Full stop. We are of the view that interest of justice will be subserved if the delay of 54 days is condoned in order to hear the accompanying appeal on merits. Accordingly, the instant application, instant interlocutory application, it stands allowed the registry to register the accompanying appeal and thereafter, to list the same for admission. Timing. Timing to ahibabone? Is timing?
Obliged.
Yes, any idea?
Lordship, they have informed us that we served the notice from the office. But the report come to registry, Lordship. It doesn't come to our office, Lordship. So the office staff are saying that they have informed our PP so that some improvement may be.
Okay, we'll ignore them. Heard Mr. D.K. Pradasai, learn it.
Only in the IA I've been engaged.
Huh?
And Lordship, objection is also filed, but as there are two, Lordship, one for amicus curiae for main criminal appeal, and my learned friend is appearing. So office is getting puzzled to whom they will give the objection. I haven't, but they have filed. They have filed. Lord.
I heard Mr. D.K.
Just-
Pradasai, learned counsel for the applicant. Why there is need for defending the appellant on state expenses? If private counsel is being engaged for interlocutory application.
Not private counsel, my lord. Actually, there's an organization who does some legal work, free legal aid. So while making a jail visit, we came across this person. So because of his medical health, so they approached us just for the bail. Just a
But
pro bono
the
matter.
practice is not appropriate. This practice is not appropriate.
Only for the bail we have been engaged, that's all.
But when state has engaged a legal aid counsel or amicus,
My lord.
then for the purpose of this application, another counsel Sit, engagement of another set of counsel is not. I don't know. Whole hog, one should, whole hog.
Ask Mr. the amicus to,
Where is it?
not
Who is the
here.
appellant? Who is the counsel for the appellant?
he's not here.
Hmm? He is also conspicuously absent. D.K. Bhattacharya, learned counsel for the applicant. But we have some reservation
My lord, I understand.
about this kind of
Keep it in mind.
practice. And A. Begum, learned additional public prosecutor for the opposite party number 1, State of Assam. Poster. M.S. Begum, learned additional public prosecutor, has submitted that she has received information from the officer in charge.
Borpeta.
Borpeta Police Station. Borpeta Road Police Station. That notices opposite party number 2.
Respond number 2, my lord.
And who is the victim?
Victim is the girl.
Name.
Father.
Name.
The victim's name,
It starts with M.
M.
M. Begum.
Begum.
Killed his wife. And he was found inside the four corners. And according to PW1, who is the son, my lord, stepson of the accused person, when he arrived at the place of occurrence, door was locked, and he also threatened him as well as the other neighbors.
106.
106. According to us, my lord, prosecution.
Your case is 106.
My lord.
So there was no explanation.
There was no explanation, complete denial.
Okay. And it is a case of homicide. I mean, it's
My-
murder.
Lordship.
Let us see the PM report.
case 65.
65. Single or many?
Many, my lord.
Many.
Page 66, chop wound of size 16.
1,
brain
chop wound, 2, 3, 4, 5, 6, 7, 8. Inside 9.
10 wounds.
Chop wound and 1 inside wound.
Yes.
And what is the opinion?
Op-
Sharp.
Yes.
Sharp edged. Homicidal. So far as the death is concerned, it is homicidal. Murder.
Lordship.
Now case is who is the assailant.
Right.
And according to you, that accused was found inside the room
My lord.
with the body of
My lord.
the wife.
Yes.
And it was locked.
My lord. It was locked from inside. They peeped through the ventilator and they witnessed.
And what are the other circumstances?
They used to quarrel, my lord.
Hmm. Anything preceding the event and subsequent to the event? Any confession?
Nothing.
No confession. Weapon of assault?
Weapon was my lord mid down. Page
Any
62.
recovery?
He was like while the police when he was lordship shouting, my lord, neighbors also lordship heard. They informed the police. Police arrived. Then he was apprehended there.
Sent for forensic? No. No blood stain.
That was there, but lordship
No forensic.
no police.
In any say in any workshop where investigating officer, public
Yes, my lord.
prosecutor,
Yes.
whether these kind of
Yes.
suggestions
Many-
are made or not?
Yes, my lord.
Huh?
Yes. Now the new law has come up, maybe.
Now Supreme Court has asked all the states to file affidavit whether there are enough forensic science laboratories or not.
Here to only one, my lord.
There is another one, nobody availed.
Knockout.
No, in this Polakbari site, Central Forensic Science. Nobody availed. I discovered it.
Oh, that's great.
It is functioning. And that is CFSL.
Lordship, during the
Nobody
COVID
says-
period,
Nobody sends anything to that laboratory. Find out from Google
yes,
whether there is Central Forensic Science Laboratory in Polakbari area or not. Yes, Mr. Ahmed, is there a CFSL? Nobody sends it? Nobody, no IO. They have facilities for on few subjects. Have you found it or not?
my lord,
Google.
Lordship, I found it. Central Forensic Laboratory.
Forensic Science Laboratory. Scientists are there
My lord.
without any, with not sufficient work. Because
So-
nobody bothers.
Maybe they are not there. I'll inform Leonard PP, my lord. Okay.
These are understaffed. FSL, Kailipara is understaffed. And see what had happened in DNA profiling
My lord.
that day.
My lord.
Yes, Mr. Kolita. When Mr. A. Kolita will be available? Tomorrow. Out of station.
This letter of absence is shown in the.
Already,
notice.
yes.
Letter of absence is there.
Yes, Lordship.
Okay. Okay, day after tomorrow. On the prayer of Mr. A. Kolita. And Kolita, right?
Yes, Lordship. Lordship, let it be after 1 week.
No, we have seen it. No question, we have seen it. We have exercised our mind. What? Only thing is to be explained, 106 is applicable or not applicable. Husband killing wife.
Brought a letter Jasmine Hospital, was 24.
Okay. And Golita.
Yes, Lordship.
Okay, on the prayer of Mr. N. Kolita Learned Counsel, appearing on behalf of Mr. A. Kolita Learned Amicus Curie, release the appeal on
23rd. Yeah.
Miss B.
24th.
Priya. Learned Senior Counsel, Additional Public Prosecutor, assisted by MS I'm Chakraborty, Learned Counsel for the respondent state, is in attendance.
24th, my lord.
24/7.
The 21st.
Oblige.
Yeah,
Item number 10,
J2 key.
Lordship, before
Yes.
takes up item number 10, item number 11, your lordship, certain instructions were sought for as regards non-appearance of PP in the Planning Trial Court, your lordship.
This matter relates to whether PP was there during trial or not, that matter, Lordship. It is wrongly listed.
Yes,
in
yes, sir,
uh,
PIL.
instructions.
Lordship, SH Bora, she is not keeping well, my lord. Wait for a short date.
That some clarification was needed by this honorable.
Yes, from the Secretary Judicial Department.
Yes,
Because they sought time.
Lord.
MS Bora is not available. You don't have any thing on here.
Lordship, I have sent it, it didn't go, my lord, because of the network, my lord. It's sent to
We'll put it on next Monday then,
mine.
Can it be
Let
on
us
Fri-
see.
Can it be on Friday, Lord?
not Friday. You have something?
No, Lord.
Okay, Mr. A. Ahmed. Heard Mr. A. Ahmed, learned counsel for the accused appellant, and MS B. Bhuiyan, learned senior counsel and additional public prosecutor for the respondent state of Assam. MS Bhuiyan has submitted that MS S.H. Bora, learned additional public prosecutor. Is absent due to personal difficulty. And as such, the information, it is not known as to whether any report has been received from the Judicial Department, Government of Assam, in deference to the order dated 26/6/2024. Full stop. As requested by MS Mia, Learned Additional Public Prosecutor, lays the case on Monday.
For orders, Lordship, in order column, Lordship.
In the order column.
Obliged, Lordship.
Item number 10.
এবার ফাইলটো পঢ়িলেও গম পাবা, লাগিলে কালি পঠাই দিম, এবাৰ পঠাই দিব, সহি আজি কৰিম, কালিৰ পিছত পঠাই দিম। হা তাৰমানে এইটো কি কৰিছে, কি নাই যে এনেকে লিখিছে দেই।
Bill, my lord, at present. My lord, on 36/2023.
Ready, madam?
I have done. I'm looking like that.
My lord, a case was registered by the Mokulma Police Station against the present appellant under section 22C of NDPS Act. my lord.
NDPS.
And my lord, after complete the investigation, the charge sheet was submitted against the appellant. The same section under section 22C of NDPS Act. my lord. And the learned special judge Nalbari, my lord, examined, my lord, total 10 number of PW. And as per the learned court, my lord, found guilty on the appellant under section 22C, and she was convicted for 12 years of the section and unlocked fine. In default of fine, another rigorous imprisonment for year, my lord. And that was the case. Thereafter, the lady, my lord, filed this appeal. And the Honorable our High Court, my lord, after hearing the bail petition, my lord, and allow her bail, my lord, on the ground that, my lord,
I do some.
my lord, hold the cases, my lord, depend upon the section 42 of NTPS Act, my lord. Because, my lord, the contraband was recovered as per the PW's statement from the house of the lady and by the 8-9 villagers of that locality, my lord. And they have conducted the search, the house, my lord. And subsequently, they informed the police, and police taken the items from them, my lord. So, my lord, the section 42 of NDPS Act, my lord, the violation, my lord, the non-compliance of that section, my lord, because they have no authority, my lord, and a person of his own interest cannot search the house of any person. He or she can also carry the item, my lord. So, my lord, the Honorable Court, my lord, observed the BA order of that BA, my lord, bail order, my lord. Honorable Court observed. Yes. Very true. Below the. How about the check this is all.
Where is the FIR?
My lord, FIR is page 22 of the paper book, my lord.
4.
22, my lord.
It's
Sorry,
4.
sorry, my lord.
Uh-huh.
4, my lord. 4 of the paper. I am reading, my lord. Humble submission is that the above named accused person has been selling intoxicated substance in our area for last few days. Though the local people have been preventing her from doing the said business, she has not stopped doing the same. As a result, some people consuming intoxicating substance available in the area have been causing disturbance in the locality. Today on 30/6/2019, we the local residents apprehended the accused and recovering the below mentioned intoxicated substance from her house. We called the police from Mokulma police station and handed over the recovered substance over to them in presence of the headman of the village. That was the case, my lord. They did not inform earlier, my lord, before conduct the charge, my lord.
MS Begum, whether this kind of SARS recovery process is permissible under the NDPS Act?
Lordship, they will have to inform the police then,
Because Section 42 has
They-
authorized certain officers
Lordship.
of the
to-
central government and state government to cause SARS recovery, seizure, and arrest. And their manner is laid down. How to do it, when to do it, sunset, sunrise. But here from the FIR and from the initial part of the testimony of PW1, it appears that it is the village people
They have done.
who
this.
took the initiatives
Lordship,
to search and recover
Lordship.
the alleged contraband substance. On the premise that the accused was carrying out business of contraband
Lordship.
for a long time, whether this kind of thing is permissible. See, if the foundation falls, the entire superstructure falls.
But the PW.
The other bricks you have laid down on the foundation.
That is their lordship. It
Right.
will be weak for me.
So whether this kind of investigation is permissible. That very I have dealt many affairs. It is invariably by an officer in charge or an authorized officer. Maybe he is authorized by an officer of a department. Maybe he is authorized or unauthorized. That is a different issue to be tested. But private FIR in case of NDPS, I have not seen. So whether this kind of process and procedure is permissible under the NDPS. First, you have to
So-
overcome that obstacle, right? You are on bail.
Yes.
Yes. Have you come across? Huh?
So the times one officer.
Invariably, I have seen it for the first time that village people, in other words, it is taking up the law in their hands.
DDP will-
It is there. It is there, PW1, that they conducted the SARS and they made the recovery. Then call police.
May not be
If
permissible.
that is so, suppose in village, things happen that one family is ostracized. If entire village populace invades his house, puts contraband, then they have to make a claim that we have recovered. Come, police, get this. We have found it from the house. Irrespective of whatever, maybe it is true that she was carrying out. But the question is the manner and procedure followed. Whether it is in conformity with the NDPS Act or it is alien to the whole procedure. How to foundation to be right. Everything falls. Everything.
GDPs of the village, lordship, it is not under the law, but they used to do this type of thing. The
No,
village-
there, what is that?
That is there, lordship.
Vigilance is okay. Vigilance, okay, is welcome. But taking the role of
Law.
that search, recovery in case of NDPS. Village Sobhapati is Sobhapati, under what kind of law he is Sobhapati, we don't know. There you go. Under what kind of Sobhapati he is Sobhapati?
Village. There are some witnesses, lordship, with the position
The
of.
question is the very foundation. Leave other evidences, whether this kind of procedure is permissible in the NDPS Act. Show me any provision. Let us have this NDPS Act. And what is the search to be made? How the search is to be made? Any idea? Any idea?
Section 42.
Section 42 is 1.
42(1), my lord. Any such officer, being an officer superior in rank of a peon, sipai or constable of the departments of central excise, narcotics, customs, revenue, intelligence, or any other department of the central government, including paramilitary forces or armed force, as is empowered in this behalf by general or special order by the central government, or any such officer being an officer superior in rank to a peon, sipai, or constable on the revenue, drug, custom, control, excise, police, or any other department of the state government, as is empowered in this behalf by general or special order of the state government, if he has reason to believe from the personal knowledge or information given by any person and taken down in the writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of the commission of such offense, or any illegal acquired property, or any document or other article which may furnish evidence of holding any illegal acquired property, which is liable for seize or freezing or forfeiture under Chapter 5A of this Act, is kept or concealed in any building, conveyance, or enclosed place, may between sunrise and sunset,
Is CIPC also?
Lordship,
I've collected-
punishment is there for vexatious entry under section 15.
to judgment also I have collected by the
Section,
58. This is the any person empowered under section 42.
it is any person empowered. These are not empowered. The question of applicability of 58 will not arise. Now, see section 51. Procedure prescribed in CRPC is to be followed. Section 51. In respect of warrants issued, arrest, searches, and seizures made. Now searches. What is the procedure? Section 100. Because private person searching house of a private person, it is like a case. Private persons searching a house of a private person. Not authorized officials. If this kind of search is treated to be legally valid, then it will be difficult. Those who have muscle powers will go to the houses of other persons and make a search, then claim that, see, this is recovered. Here it is a case of the whole village people. And the guidance of the so-called Sabhapati. What kind of Sabhapati, we don't know.
And my lord, when enter in the house, my lord, for search, when take my lord independent witness and check the body also.
Those are there, section 105.
Yes.
Before making a charge under this chapter, the officer or other persons about to make it shall call upon 2 or more witnesses. That is why they do independent witnesses
Yes, ma'am.
and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality, if no such inhabitant of the said locality is available. Under second proviso, many times, this NCB and all, they used to, police also, used to take the same witnesses everywhere,
Yes.
that persons from the locality are not available. So these are called. Already of security witness. And is willing to be a witness, then search shall be made in their presence. And a list of all things seized in the course of such search and of the places in which they are respectively found shall be prepared by such officer or other person. 105. Subsection 4 and 5. Now let us, in this backdrop of these provisions, let us see PW1. What do you say?
Lordship, PW3 is the relative of
Let
the,
us see PW1
One.
first. I think he's the informant.
he is the informant.
He's the leader also.
Lordship,
He was the leader also. Please read.
I have
Lord-
the,
Yes, Mr. Uddin,
Yes, my lord.
please read.
Yes, my lord.
Read one. PW1.
PW1, my lord. I am reading, my lord. I am the informant of this case. I know the accused Jatuki Boro, present before the court as she hails from my village. For last 4-5 years, we noticed coming of several people in the house of accused Jatuki Boro that caused suspicion in the mind of the villagers. Why several people coming to the house of Jatuki, which is unusual. I being the village Sabapati, president, villagers informed me about this fact. So we put strict vigilance and monitor the presence of coming to the house of accused Jatuki. And one day, village people along me checked the house of accused Jatuki. On checking, we found several tablets and bottle of codex in the house of Jatuki, and we suspect those are contraband intoxicated items. So we informed the police. Police arrived, inspected the house of the accused and seized the suspected contraband item and from the house of the accused Jatuki. I was present when police seized the contraband item from the house of the accused Jatuki, and the police took accused along with the contraband item to the police station. On this incident, I have lost the affair. Now, approach, my lord. Ejar was not written by me, by my handwriting. I have put signature in the Ejahar at the police station. I do not know the name of Ejahar writer. I was sitting in the same room where Ejahar was written, but I did not see the Ejahar and did not read before putting my signature in the Ejahar. I did not read over the name of the items mentioned in the Ejahar. I put signature on the Ejahar on the date of incident at about 3 to 3:30 p.m. In the house of accused Jatuki, her husband, very young son, father, father-in-law, and mother-in-law alive. But mother of her husband not stayed at her house. Father-in-law and mother-in-law of the accused Jatuki are aged person and they had hearing problem. About 50 families reside in our village. About 30 to 40 village people comprising male, female went to the house of accused Jatuki to check her house. All the 30-40 people did not enter in the house of Jatuki at the time of checking. Woman of the village told the male member to present outside the house, and women villagers entered into the house and accused Jatuki and checked her house. Therefore, I did not go inside the house at the time of checking. About 12 women of our village checked the house of the accused Jatuki. Gyasuddin Ali of village Balikusi is the Gaubura of our village, and he is bedridden, and therefore his son discharged the function of Gaubura, and his son Anush Ali was present at the time of checking. I cannot say what specific item each of 12 women found and brought from the house of the accused Jatuki. And I noticed the same when they brought the same with them outside the house. Body search was not conducted when women entered into the house of accused Jatuki. It is not a fact that contraband item, narcotic drugs are recovered from the house of Jatuki. Next, my lord. We did not inform police and Gaubura prior to checking and searching the house of the accused Jatuki. This is the case, madam. So my lord, they could have informed the police and they can assist the police, but directly they have taken the.
Vigilantism, okay, you are proactive, good, but taking up the act of search and recovery, 30 women folk entered into the house.
And PW2 also, my lord, that Anushali, the son of the
He
Gaubura,
is Gaura,
he, my lord,
Gaura's son.
yes, my lord, he subsequently came, my lord. He also came, my lord, after the complete the charge, my lord. And PW3, my lord, Banjit Boro, my lord, just on important line I'm saying, my lord, in Cross, my lord, page 17, my lord, the,
Seen, second para.
third para, my lord. I
No.
cannot say what each of the lady found the brought out from the house of the accused.
First line, about 10, 12 village women made search
Yes,
in
yes,
the
yes.
house of that.
Yes,
You have skipped that.
Yes, no, my lord.
Ah.
About 10, 12 villagers women made search in the house of the accused Jetuki who found this item. Yes, my lord. I know name of some of the ladies who made search in the house of accused Jetuki. They are Minoti, Anita, Mina, Ila, but I cannot say name of all the ladies as I do not know their name. I did not.
And why only the appellant? Her husband was present. Her father-in-law, mother-in-law was present inside the house. Right. Then there were others also.
Yes, my lord. Paragraph, my lord.
Young son, her husband was present,
Yes, my lord.
but nothing against the husband.
PW4 also, my lord, in last line, I did not enter inside the house of the accused Jetuki. And they are also saying that, my lord, they have like they are angry with that family. So enmity also come here, my lord.
Who says?
My lord, the APW one says that the villagers is not like them. So when prior to the incident, they are not like the family member. But I have collected judgment of the Honorable Supreme Court, my lord.
Okay, we'll
Yes,
take note. Let us
yes, yes.
go to the evidence first.
Yes, my lord. Next, PW6 also, my lord, in SIP, my lord, stated. PW6, my lord, I know accused Jetuki Boro. I know the informant, Biren Boro, and he is the village president of our village. Accused Jetuki Boro is selling van contraband and other contraband items for last 2-3 years. And the villager asked her to refrain from the selling van and other contraband item in the village, but she did not listen to the villagers, people. When Jetuki Boro did not listen to the village people, villagers sit together and decided to search the house of the accused, and then village people charged the house of the accused. They recovered contraband items, the bottle and bottles, and therefore village people apprehended her with the contraband items, informed police, and handed over her to the police with contraband item.
She was earlier warned by the villagers, lordship, not to sell. Many times the villagers have warned her. That is also there.
The warning is all right.
That is their lordship, but
And informing the police,
that is
also all right.
That is the lacuna.
But informing subsequent to search and recovery
That is
is not perhaps proper. Information prior to, should have been prior to.
That-
And the entire search should have been carried out by,
in front of police or. But she is selling out. That is also
Lord,
their lordship.
that will not.
Because every
You are
villager
dealing with NDPS.
What?
Strict provisions
under the law.
requires strict compliance.
That is it.
PW8 also.
Now suppose this is allowed, then village people will go to a person's house, invade the house, make a search, plant materials, then call police.
Violated.
Uh,
That is-
free hand.
that is okay.
Suppose 100 people go there,
Lordship, lordship.
then made a search, then plant materials, then they have to call police. Police coming there, prepare a seizure list, and court putting a
After
Stamp
informing,
of
they could have
approval.
informed the police that after warning her, they could have informed the police that
Yes, they should
something
could have
is going
lodged the
on.
complaint.
That
CPW 5. She was one of those women who made SARS
Yes.
and recovered contraband. And this Gabara was called later on. Thereafter, police. Later.
she kept the tablets, lordship, in PW8 under a LPG cylinder, lordship, by making a hole on the art. And above it, she put the LPG cylinder, PW8.
See the statement of PW 8 also, last line. Did not, earlier villagers did not inform police that accused is involved in selling contraband items at our village.
And well, the cross part of the IO also, my lord, clear, IO also admitted.
We have not reached the IO.
The cross part of the I am reading well. Page 30. Oh, sorry.
Nice, I saw. On what ground the trial court found this to be proper procedure? Anything, any discussion?
My lord, the learned trial court, my lord, clearly not discuss about the section 42 regarding the charge. The learned trial court discussed this because contraband was recovered from the house. And first order, it is not clearly mentioned. And discuss the section 50. Section 50 is the individual person when,
Body.
yes, my lord.
That is body, I think.
Paragraph 50, my lord, page 59 discuss about the section 50. 54 this, but
Yes,
properly,
Ms. Begum, defend the case. I'll come back.
Lordship, in the judgment part, Lordship, page number 61, her son is also deaf, Lordship. So her son, Lordship, regarding the son, he is deaf. And her husband also died, Lordship. Means, I want to say, as they are not in the picture, Lordship, husband and son. Son, page number 61 of the judgment part, Lordship. The first paragraph, on regarding the son, Lordship.
61.
Page number 61 in judgment, Lordship.
Huh?
It is mentioned that after look after her deaf son, Lordship. Son is not in the picture of why he is not alleged, Lordship.
That is on the point of sentence.
See, Lord sentence, but I'm saying that regarding them, Lordship, as it is not mentioned anywhere that her husband also died, Lordship.
no, when she was in jail, then husband died.
Let's see, maybe he was suffering from some disease. So that is only she was alleged to be accused, Lordship. And session court also have decided beyond all reasonable doubts, Lordship.
আৰু সেইটো section 51, section 51, 105, 105 to হেৰি কৰিব লাগিব। Procedure to just for us. 4 and 5. Before making any search. So 2. And these village people, they cannot be said to be independent. Search and recovery was made,
By the police,
not by police.
public.
Seizure was made
Seizure was made by police.
by
Inventory
police,
was
but
prepared
search
by-
and recovery was not made,
That was not made,
admittedly.
admittedly, but seizure inventory, that is. in the
Inventory
procedure.
52A compliance is one part, but
Right.
prior to that, there has to be proper search, recovery and seizure
Seizure,
in a manner contemplated under the NDPS Act.
that is it,
If the manner is not contemplated,
that is it. But the thing is also that witnesses have said that she was warned from 2-3
But
years that.
it appears
she
to
is
be
in-
all these are interested now. They fall in a category of interested witnesses, not independent witnesses. And search is to be made in presence of independent witnesses by the police.
Okay.
Now, suppose this kind of search is made permissible, what will be the consequence?
That is their lordship, that is there, the thing is that she was doing this business and it is.
That is another matter.
It is commercial
But
and she is selling.
They
tablets
could have
also.
warned it, okay, right, that stop selling
Stop it,
this
because
kind of things.
the-
Then if she did not stop, duty on the part of this village people was to inform the police by making a complaint,
Lordship,
and that can be treated as an information under section 42.
that is lordship, that is.
Thereafter, this authorized empowered officer
lordship.
can make the search,
And-
and if found, made the recovery, then thereafter seizure list in presence of available witnesses, independent, by following the procedure as per section 51. That is not done apparently.
All the tablets, lordship.
Hmm?
See tablets. also.
Yes, we know. We know, but what you have done? Taking up the
The hand of.
law is also not permissible.
Pharmacy.
Other parties after seizure, maybe compliance.
After.
52A, drawing of samples, sending
everything
it to
is
the FSL, getting the report, okay. But the events prior to
That is.
seizure list, those are not contemplated. আরম্ভ করে দিম আৰু তাৰপিছত ক'ত ফিল আপ কৰিব লাগিলে কৰি দিম আৰু ন? The present criminal appeal under section 374 within bracket 2, Code of Criminal Procedure. Please take your seats. 1973, the Court and Order here is preferred to assail a judgment, an order dated 6/8/2021, passed by the Court of Learned Special Judge comma Nalbari, within bracket the special court. In NDPS case number 24 of 2019. Full stop. By the judgment and order dated 6/8/2021, comma, the learned special court has convicted the accused appellant for the offense under section 22. Within brackets, small c, of the Narcotic Drugs and Psychotropic Substances Act, comma, 1985, within bracket NDPS Act for short. And she has been sentenced to undergo rigorous imprisonment for 12 years and to pay a fine of rupees 1 lakh, comma, in default of payment of fine, comma, to undergo simple imprisonment for another 1 year. Full stop. The accused, it has been observed that the accused appellant would not be entitled to the benefit under section 428 CRPC. Set-off was also not made permissible. Full stop. The investigation commenced on the basis of a first information report lodged by one Biren Boro, comma, a resident of number 2 Khoga, within bracket Madla Bori, comma, police station Mukalmua, district Nalbari, before the officer in charge, Mukalmua police station, on 30/6/2019. Full stop. In the FIR, comma, the informant Biren Boro, within bracket PW1, had inter alia alleged that the accused person had been selling intoxicating substances in their locality from a prior period, from an earlier period. Full stop. Though the informant had stated that though the local people had asked her to stop from carrying out such business, the accused did not stop doing the business, full stop. As the business carried out by the accused who was causing disturbance in the locality, the local residents, on 30/6/2019, apprehended the accused and recovered the suspected contraband substances, mentioned in the FIR, from her house. Full stop. The police the matter was thereafter informed to Mokalma police to the police at Mokalma police station, and the recovered suspected contraband substances so recovered, were handed over to them in presence of headman of the village. Full stop. Para. On receipt of the FIR, the officer in charge registered the same as Mukalmua Police Station case number 314/2019 under section, for the offense under section 22 within bracket small c, NDPS Act on 30/6/2019, and took up the investigation of the case himself. Full stop. The accused person was taken into custody on 30/6/2019 itself. Full stop. During the course of investigation, the IO, the investigating officer IO, Roman, and officer in charge, Mukalmua Police Station, during the course, on being handed over the suspected contraband substances, so recovered by the village co-villagers, the police personnel who arrived at the place of occurrence on receipt of an information to that effect, prepared a seizure list, EXT, two, and took the accused person to the police station along with the quantity of the suspected contraband substance, so recovered. First stop. During the course of investigation, the IO and officer in charge, Mukalma Police Station, PW9, recorded the statements of witnesses under section 161 CRPC, semicolon, drew up a sketch map of the place of occurrence within bracket EXT3, and roll up. Full stop. The IO also prepared an inventory of the seized contraband substance and submitted an application before the jurisdictional magistrate by producing the seized contraband substance before him, making a prayer to allow drawal of samples and to send the samples for examination to the Forensic Science Laboratory, FSL, full stop, on being permitted by the magistrate, learned magistrate, samples were drawn from the seized contraband items and forwarded those samples to the FSL, Assam at Kahilipara for examination. Full stop. As in the meantime, PW9 was transferred, another investigating officer, PW10, completed the remaining part of the investigation by collecting the FSL report from the Directorate of Forensic Science, DFS, Assam. Full stop. After completing investigation into the case, Mukalmoa Police Station case number 314/2019, within bracket corresponding to ZR case number is there any ZR case number? Okay, another investigation, PW10 will leave another investigation officer, Utpal Kumar Nath, PW10 na lage. Submitted a charge sheet under section 173 within bracket 2, CRPC, finding a privacy case under section 22C NDPS Act, well established against the accused. Post para. After submission of the charge sheet, on submission of the charge sheet, the learned special court, after hearing the learned special public prosecutor and the learned defense counsel and Upon perusal of the materials of the available in the case records, comma, framed. Initially framed a charge against the accused on 17/1/2020. Full stop. Subsequently on the difference key. Modulabari so and so past. I can. Hey, LCR reduction. Why charges were framed on 2 occasions?
Well, initially it was framed the charge under section 22B and subsequently charge was altered to 22C, my lord. Page
Okay.
46, my lord, of the.
Under section 22B of the NDPS Act. Full stop. Subsequently on 5/4/2021, Command Special Code, having regard to the quantity of contraband substances, comma, altered the charge in the following manner. Page 7, A2, A2A. When the charge framed under section 22 within bracket C, it should be small c, I think. Small c. NDS PS Act 1985 was read over and explained to the accused, comma, C pleaded not guilty and claimed to be tried. Full stop. During the course of the trial, comma, the prosecution side examined 10 number of witnesses. Page 64. And exhibited 6 number of documents, page 64. After closure of evidence from the prosecution side, comma, the accused was examined under section 313, comma, CRPC by putting the incriminating materials emerging from the evidence of the prosecution witnesses. Full stop. The plea of the accused was of denial. Full stop. However, the accused did not adduce any evidence in her support. Full stop. After hearing the learned counsel for the parties and appreciation of the evidence stroke materials on record, comma, the learned special court passed the judgment impugn judgment convicting the accused for the offense under section 22C NDPS Act, and the accused has been sentenced in a manner, comma, mentioned above. Full stop. We have heard Mr. Anuddin, learned counsel for the accused appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Full stop. Mr. Uddin, learned counsel appearing for the accused appellant, has submitted that the there was total non-compliance of the provisions contemplated in, prescribed in section 42 of the NDPS Act, which has laid down the which has provided for entry, search, seizure, and arrest, etc., in respect of an offense under offense in connection with contraband under the NDPS Act 1985. Full stop. In the case in hand, it was the co-villagers who had made forcible entry into the house of the accused and during the search purportedly carried out after such entry, alleged to have recovered the contraband items, mentioned in the FIR. Full stop. The procedure required the mandatory procedure required to be followed in case of zero five now 105. Ah. H. Are required to be followed, as laid down in section 51, NDPS Act and section 105, CRPC were not followed. Full stop. It was only after the alleged recovery of the contraband items, the police was informed and full stop. And the police personnel who arrived at the place of occurrence subsequently, had prepared a seizure list and arrested the accused. Full stop. It is the contention of Mr. Uddin and Uddin. It is a contention of the learned counsel for the accused appellant that the investigation carried out after such illegal search and recovery was was in total compliance, non-compliance of the total non-compliance of the provisions contained in section 42 of the NDPS Act. First of the offenses under the NDPS Act 1985 being serious in nature and the person convicted of the offense is visited with stringent punishment, comma, the procedure requires strict compliance. Full stop. In view of such non-compliance on the part of the such non-compliance, comma, of the mandatory procedure, comma, as mentioned, as contained above, comma, the judgment and order of conviction and sentence passed against the accused appellant is liable to be interfered with. First on para opposing the contentions of the learned counsel for the accused appellant, comma, MS Begum, learned additional public prosecutor, has contended that after recovery of the suspected contraband substance, comma, the procedure laid down in section 52A of the NDPS Act regarding preparation of an inventory, comma, taking of photographs of the contraband substance items, seized contraband substance items, and permission to draw samples therefrom were with due certification of the jurisdictional magistrate. First off, it is the further contention of the learned additional public prosecutor that the contraband quantity of contraband items recovered from the house of the accused fell into commercial quantity. And as such, comma, the act of search and recovery by the co-villagers from the house of the accused would not vitiate the investigation of the case as the required procedure were followed. During the course of investigation to submit the search sheet. Full stop. And that it is contended that the testimonies of the witnesses, prosecution witnesses, had clearly established that the accused was involved in the business of contraband items from her own house premises. Condemning so, the learned additional public prosecutor has submitted that the judgment and order of conviction and sentence does not require any interference. First off, we have given due consideration to the submissions, rival submissions of the learned counsel for the parties, and have also perused the evidence stroke materials available in the case record of special case number and NDPS case number so and so in original. Stop it. Where out of the 10 prosecution witnesses, out of the 10 prosecution witnesses, comma, the prosecution witnesses dash PW1, PW2, PW3, PW4, PW5, PW6, PW7, PW8, and PW8 were co-villagers and or relatives of the accused. First off, PW9, Jayanta Kumar Burman was the IO of Jayanta Kumar Burman, the then officer in charge Mukalma Police Station, who was the IO of the first part of the investigation, and PW10 was the scientific officer, Drugs and Narcotic Division, Directorate of Forensic Science, Assam. Before proceeding to before a discussion on the testimonies of the prosecution witnesses, it is relevant to mention that the contraband items involved in the case were case 32. Case 32. 1, 2, 3, 4, 5. Which were shown to have been allegedly seized on 30/6/2019, while a seizure list, EXT2. Full stop. Admittedly, the total quantity of the contraband items, comma, mentioned above, comma, fell in the commercial fell in the category of commercial quantity. Full stop. Para. As the learned counsel for the accused appellant has strenuously contended regarding the manner of search and recovery of the contraband items from the house of the accused, comma, it is necessary, it appears appropriate, comma, at first, comma, to discuss the evidence emerging from the prosecution, from the evidence emerging in that connection. Full stop. Para, sub-para. PW1 claimed himself to be a Sabhapati, within bracket president, of the village comma, village number 2, Khoga, Ghoza, within bracket Madlabori. Full stop. PW1 deposed to the effect that for about 4 or 5 years, comma, the village people were suspecting that the accused was carrying out illegal activities from her house as from her house. Full stop. When on the date of the incident, comma, village people along with him, comma, this had made a search of the house of the accused. On being searched, comma, several tablets and bottle of Codex were found in the house of the accused. And those were suspected to be contraband items, comma. It was decided to inform the police. On being informed, comma, police personnel arrived at the place and inspected the house of the accused and seized the suspected contraband items from the house of the accused. He claimed that he was present when the police personnel seized the contraband items from the house of the accused. He deposed that the police personnel took the accused along with the contraband items to the police station. Full stop. In cross-examination, comma, PW1 stated that about 30-40 village people comprising both male and female went to the house of the accused to search the house. Full stop. Though all of them did not enter into the house of the accused at the time of search, comma, about 12 women from the village entered into the house of the accused and searched the house, while the male members of the team were remained outside the house. Full stop. PW1 further stated that he did not read the contents of the FIR wherein EXT1, wherein he gave his signature as EXT11. Full stop. PW1 further disclosed, comma, in his cross-examination, comma, that at the time of making the charge, comma, the husband, comma, a son, comma, the father-in-law and the mother-in-law were present apart from the accused. Full stop. The PW1 further stated that they did not inform the police and the Gambura prior to checking and searching the house of the accused. Full stop. PW1 had, comma, however, comma, denied a suggestion that they had falsely implicated the accused by telling that the contraband items were recovered from her house. Will resume? Two. PW2 was the son of village Gambura of village Baligusi, comma, Giyasuddin Ahmed. Full stop.
Universally, well,
Huh?
PW2, universally. His son of
No,
the
his name is not mentioned. PW2, comma, likhibo pada Yunus Ali. Was the son of the village Gambura of village Baligusi, comma, Giyasuddin Ahmed. Full stop. As his father was bedridden, comma, the village people called him to represent his father to the house of the accused by informing him that the police personnel had already arrived at the house of the accused person. Full stop. He accordingly went there and noticed contraband tablets and bottles in the compound of the accused person. Posto. He stated that police seized the same and took his signature in the seizure list prepared by the officer in charge, Mukalma Police Station, PW9 at the place of seizure. Posto. He exhibited the seizure list EX, EXT2 with his signature therein as EXT21. Full stop. In cross-examination, he PW2 stated that the seizure list, EXT2 was prepared after his arrival at the place of seizure, but he did not go through the same before putting his signature, as he was not acquainted with English language. Full stop. Para. PW3 knew PW1 as well as the accused, who was her relative. Post of PW3 deposed to the effect that the accused was found engaged in selling contraband substances and the villagers noticed visits of large number of people to her house for some times. On the incident, he deposed that a large number of villagers, both male and female, made the search in the house of the accused and found contraband items therein. Full stop. He stated that he was also present at the time of search and recovery of the contraband items from the house of the accused. Full stop. He further stated that only women from the village entered into the house of the accused, entered and searched the house of the accused on that day. Full stop. Thereafter, the Gambura was called and the police was informed. Full stop. Police personnel took the recovered contraband items from the house of the accused in his presence by preparing a seizure list, EXT2, wherein he subscribed his signature as EXT22. Full stop. In cross-examination, PW3 stated that he was present at the time of arrival of police. Full stop. As regards entry and recovery, PW3 stated that about 30 villagers were present at that time and 10/12 village women made the search in the house of the accused and found the contraband items, comma, which were seized. Full stop. He named few women who made the search and recovery. Full stop. He further stated that he could not say about the items the woman, WOMEN, brought out from the house of the accused. Full stop. After arrival of the police personnel, comma, the recovered contraband items were seized and photographs were taken before preparing the seizure list. Full stop. Para. PW4, comma, remain Boro knew the informant as PW1 and the accused, comma, as they were his co-villagers. Full stop. Like PW1 and PW3, comma, PW4 also deposed to the effect that visits of outsiders to the house of the accused were noticed for a long time. So, and accordingly, comma, the villagers decided to go to the house of the accused to find out the reason behind visits of outsiders to her house, frequent visits of outsiders. Full stop. As regards the incident, comma, PW4 stated that on the date of the incident, comma, the villagers, comma, both male and female, comma, went to the house of the accused and few men made a search in the house of the accused and made recovery of contraband tablets and bottles from inside the house. Full stop. He stated that he was present at a time of search and recovery, such search and recovery, whereby the village women recovered those contraband items and bottles from the house of the accused. Full PW4 stated that the village president was thereafter informed, and after arrival of the village president, comma, police was informed. Full stop. The police personnel, after their arrival, comma, seize the recovered contraband items from the place of occurrence by preparing a seizure list, ext2 wherein PW4 gave his signature as ext23. 2 in bracket 3. Full stop. In cross-examination, PW4 denied the suggestions made to him full stop. He stated that he did not read the contents of the seizure list, ext2 before giving his signature therein. Full stop. He further stated that he did not enter into the house of the accused. Full stop. Para. PW5, another co-villager, stated that he knew both the informant, PW1 and the accused. Full stop. PW5 also deposed to the fact that villagers noticed frequent visits of outsiders to the house of the accused, spoiling the atmosphere of the locality. Since long. Full stop. Corroborating the testimony is of the other PWs, PW5 stated that on the date of the incident, the villagers, both male and female, went to the house of the accused, and about 12 women, including herself, PW7, PW7, and PW8 made searches in the house of the accused and recovered contraband tablets and bottles. Full stop. PW5 further stated that after such search and recovery, the village Gambara was called, and on being called, the son of the village Gambara, PW2 came to the place. Full stop. The police was thereafter informed. Full stop. After arrival of the police personnel, the recovered contraband items and the accused were handed over to the officer in charge, Mukalma Police Station, PW9. Full stop. PW9 then asked PW4 and one Bonti Boro to count the recovered contraband items. Full stop. Thereafter, comma, the police seized the scene and took custody of the contraband items along with the accused person. Full stop. During cross-examination, comma, PW5 reiterated that about 12 women, including herself, comma, PW6, comma, PW7, and PW8 made searches in the house of the accused and recovered the contraband items. Full stop. PW5 also stated that at an earlier point of time, earlier, comma, the accused was asked to stop from carrying out the activities in her house. Full stop. PW5 admitted that neither the police nor the Gaon Panchayat was informed as regards the alleged activities carried out by the accused in our house at any earlier point of time. Full stop. On the date of the incident also, comma, the Gaon Panchayat was not informed that the villagers were going to the house of the accused to search the house. Full stop. PW5 denied the suggestions given to her by the defense side. Full stop. Para PW6. Comma, another co-villager, comma, corroborated the testimonies of the other witnesses to the effect that the accused was earlier asked to refrain from selling contraband items in the village. Full stop. As the accused did not listen to the village people, comma, the villagers decided to search the house of the accused. Full stop. Accordingly, comma, search of the house of the accused person was carried out on the date of the incident, and during search, comma, recovery of contraband items like bottles and tablets were made. Full stop. Then, comma, the villagers apprehended the accused and informed police. Full stop. The accused and the contraband items so recovered after search, comma, were handed over to police. Full stop. In cross-examination, comma, this witness denied all the suggestions given to her by defense. Full stop. Para. PW7 is another co-villager and witness, comma, comma, a co-villager and a niece of the accused, comma, deposed that she knew the informant, comma, that's PW1 and the accused. Full stop. PW7 further deposed that contraband items like tablets and bottles were recovered from the house of the accused when village women searched the house of the accused. Full stop. Even prior to the search, comma, the villagers the villagers asked the accused to refrain from selling contraband items. Full stop. PW7 further stated that after recovery of the contraband items from the house of the accused, comma, the village president, comma, PW1 and police were informed. Full stop. After arrival of the Gambura and the police personnel, comma, the accused and the contraband items recovered during the search, comma, were handed over to police. PW7 further stated that on the date of the incident, comma, several villagers were present in the house of the accused. Full stop. In cross-examination, comma, PW7 denied all the suggestions given to her by the defense. Full stop. Para. PW8 was another co-villager, comma, who knew the informant as PW1 and the accused. Full stop. PW8 also stated that it was noticed by the villagers that the accused was doing business of selling contraband items. And the villagers noticed frequent visits of persons to her house. Full stop. The accused was asked to refrain from selling the contraband items, but the accused did not pay any heed. Full stop. On the date of the incident, comma, the villagers, comma, both male and female, comma, went to check inside her house, and on checking the house of the accused, comma, bottles of contraband items and contraband tablets under LPG cylinder was by making a hole on the earth and above was found. Full stop. Those contraband tablets and bottles were recovered, and the village Gambura, comma, the village president and the police were informed thereafter. Full stop. The village president, comma, PW1 and police personnel arrived on receipt of such information about recovery of contraband items in the house of the accused. Full stop. Thereafter, comma, the accused and the contraband items so recovered, were handed over to police. Full stop. The police personnel then took the accused person and the contraband items to the police station. Full stop. In cross-examination, PW 8 stated that earlier, the villagers did not inform the police that accused was involved in selling contraband items at their village. Full stop. Suggestions put to this witness by the defense side were denied. Full stop. PW 8 had, however, admitted that she did not state before the police in her previous statement that the contraband items were found kept in the bag of the accused and under the LPG cylinder by making a hole on the earth and above. Full stop. Para. Full stop. Para. From the testimonies of the above prosecution witnesses, it is clearly demonstrated. Now it has unerringly emerged that it was the village, it was the co-villagers numbering about 30, proceeded to the house of the accused on the date of the incident, that is, 30/06/2019. Full stop. The reason behind proceeding to the house of the accused on the date of the incident was, according to these PWs, that the accused appeared to be involved in the activity of selling contraband items to visitors, who used to make frequent visits to her house, resulting into and such frequent visits and such an indulgence or in such activities had disturbed the peaceful atmosphere in the village. Full stop. It has further emerged that after assemblance of the villagers in the house of the accused, 10/12 women from among those villagers entered into the house of the accused and carried out searches inside the house of the accused. Full stop. It has further emerged that at the time of such searches, the other inmates, like the husband, a son, and the father-in-law and the mother-in-law of the accused were also present. Full stop. It has further emerged that after making out upon such search, the villagers had purportedly recovered suspected contraband items, as mentioned in paragraph so and so above. Full stop. From the house of the accused. Full stop. It has further it has further emerged that it was after such search and recovery, the village Gambura and the village president were informed. Full stop. It is not known. It has not emerged from the evidence stroke materials on record, from record that in what capacity, the informant as PW1 had discharged, had claimed himself to be the village president. Full stop. So far as the village Gambura is concerned, the prosecution witnesses, it has emerged from the testimonies of the prosecution witnesses that at the time of the incident, the village Gambura was suffering from ailment, and in his place, his son, PW2, came to the place of occurrence, that is the house of the accused. Full stop. It has further emerged that after search and recovery of the suspected contraband items, the villagers decided to inform the police personnel of Mukalmua police station. Post. Clear. The events after the arrival of the police personnel from Mukalmua police station and the place of occurrence can be noticed from the testimony of the then officer in charge, Mukalmua police station, PW9. Stop. In his testimony, PW9 stated that at about 1:30 PM on 36/2019, the president of village number 2 Ghoga, PW2 informed him over telephone that at village number 2 Ghoga, Madlabari, the villagers kept the accused along with kept the accused apprehended at her house along with certain suspected contraband items. Post op. PW9 stated that after getting the information, he conveyed the information to the Superintendent of Police, Nalbari, and as per the instruction of his superior officer, and as per his instruction, he visited the place of occurrence, that is the house of the accused, situated at village number 2 Ghoga. So on reaching the place of occurrence, he found the accused and the accused with the contraband items in her possession. Full stop. The accused was thereafter, taken into custody, and he seized the contraband items found in possession of the accused in presence of witnesses, by preparing a seizure list, EXT2 at the place of occurrence. Full stop. He testified that the contraband items so seized he testified that the contraband items, as mentioned already in paragraph so and so above, were seized by the seizure list, EXT2, and he identifies his signature therein as EXT2 within bracket 4. Full stop. He further stated that the signature of the accused was also taken in the seizure list, and he identified the signature of the accused as EXT25. Full stop. The FIR within bracket EXT2 was thereafter lodged at about 5 PM on 36/2019 by PW2. Full stop. PW9 further stated that he sealed the packets of the seized contraband items and brought the accused along with the seized contraband items to the police station. It was after receipt of the FIR EXT1, the case, Mukalma Police Station, case number 314/2019, under section 22 within brackets small c of the NDPS Act 1985 was registered. Post op. PW9 further stated that he made another visit to the place of occurrence on 1/7/2019 to record the statements of the witnesses and to prepare the sketchmate of the PO within bracket EXT3. Full stop. PW9 further stated that he prepared an inventory of the seized articles and produced the same before the learned magistrate, and took samples from the contraband items. Full stop. A prayer was made before the learned magistrate to send the samples, which were taken from the seized contraband items to the FSL for examination. Full stop. It was thereafter, the samples were taken out from the seized contraband items and forwarded to the FSL for examination. As during the course of investigation, he was transferred from the post of the officer in charge, Mukalma police station. The remaining part of the investigation was completed by his successor, successor officer in charge, BIJ, Utpal Kumar Nath, Inspector of Police. Full stop. The successor IO, PW9 stated that the successor IO, collected the FSL report and submitted the charge sheet within bracket EXT4 against the accused. Full stop. In cross-examination, PW9 stated that the villagers found the contraband items in possession of the accused and kept the accused apprehended with the contraband items. On receipt of the information regarding recovery of contraband items from the possession of the accused, a general diary entry number 701 dated 36/2019 was registered. The said general diary entry was, however, not exhibited during the trial. Full stop. As regards the place of occurrence, PW9 stated that the place of occurrence was the house within bracket courtyard of the accused, situated at village number 2, Khoga, Madlabari. Full stop. PW9 further stated that it was the villagers who informed him about the recovery of contraband items from the house of the accused. Full stop. PW9 stated that the villagers did not specify from which room of the house of the accused, the contraband items were recovered. Full stop. On reaching the place of occurrence, after getting the information, PW9 noticed the contraband items with the accused in the courtyard of the accused, and the contraband items were kept in a white carton. Full stop. Madam, where is the inventory also? Where is the drawal of samples? Where is the photographs? Nothing. Maybe in the file, not before the trial court.
Between the ancient lordship.
এই না judgment তো যে দিছিল কেনা judgment বিশ্লেষণটা print out হয়েছে। But having it in the FIR inventory put করেছে
Paper.
some 86. Right. Right. Figures. This exhibit, page 87 was exhibited. I don't think so. নহয় ন সেইদিনাখন যে জাজমেণ্টটো দিছিলো এই কলিতা আমাৰ ৱেবছাইটত আছে চাগে after cross-examination, PW9 was further examined. Nine. নাই কৰা not exhibited LCR to Dixon. Huh?
Page number 86.
80
86.
86 we have seen, but where in the evidence who had exhibited this?
See page 64 of the judgment in the paper book.
LCR to exhibits. See, these are the problem. Hey, GR case number 1180/2019. 1180/2019. সহি আছে কিন্তু সহিয়াতে আছে থাকিব লাগিছিল তো signature was there in the inventory, but nowhere
In the.
mentioned in the testimony of PW9 that he had exhibited the inventory. He said about the preparation of the inventory.
But you have not, but it is exhibited in the testimony he have not mentioned, but it was exhibited as 7 here. Signature,
There is no mention.
there is no mention.
Oh, no, it is there. On further. It will. On the question, further equal line to. No, last line. Of PW9, he was he was further examined by the prosecution full stop. During such further examination, PW9 mentioned about the contraband articles which were seized by seizure list, XEXT2. Full stop. He further deposed about the preparation of the inventory of the seized contraband articles and exhibited the inventory as EXT1 and identified his signature and the signature of the learned magistrate as EXT71 and EXT72 respectively. Full stop. When he was further cross-examined by the defense, PW9 denied the suggestion that he did not seize the contraband items, mentioned in EXT2, as per the seizure list and the inventory. Full stop. Para. PW10, Sondan Das was working, on 4/7/2019, as the scientific officer in the Drugs and Narcotic Division, Directorate of Forensic Science, Assam. Full stop. PW10 stated that on 4/7/2019, he received a parcel from his director in connection with Mukalmua Police Station, case number 314/2019 for examination. Full stop. The parcel consisted of 17 exhibits enclosed in a sealed carbon box with cloth cover. Following exhibits, following exhibits. Page 33. B to B. He deposed that he carried out examination of the exhibits and recorded his findings in a report, which he exhibited as EXT5. Full stop. The results of the examination recorded in the report EXT5, whereas under C to C, page 34. PW10 also exhibited a forwarding report, EXT61, whereby EXT5 report was forwarded to the officer in charge, Mokalma Police Station. Full stop. When PW10 was cross-examined, he stated that he did not see the examined materials before him. Full stop. Vera. Before going to the aspects of search, recovery and seizure of the contraband items, mentioned in the seizure list, ext2, it appears apt to the events subsequent to such search, recovery and seizure. Full stop. A223. A2 fault of no. 452A. Inventory clear, sir. Needs to make an application to an industrial application. Photographs, exhibit কৰিব তাৰপিছত simple draw কৰা এখন লাগিব magnetics concealed application এইটো তাৰপিছত মংগীলাল চলিমলৈ কৈছে এইটো যদি নহয় it is illegal. So list of samples নাই কৰা photograph কৰা নাই, basically the contraband items was not exhibited. Here paragraph 23 to লিখি দিব paragraph 23 of criminal appeal jail 84 2020 অলপ correct modify কৰি দিম আৰু মই from the it has been reiterated in the decisions in Union of India versus Mohanlal, reported in 2016, 3 SSC 379 and Mongilal versus State of Madhya Pradesh, reported in 2023, 10 SCR 517. That upon seizure of the contraband, the same has to be forwarded to the empowered officer as mentioned in section 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for the purposes of A, certifying the correctness of the inventory, B, certifying photographs of such drugs or substances taken before the magistrate as true, and C, to draw representative samples in the presence of the magistrate and certifying the correctness of the list of samples so drawn. Full stop. As per the mandate contained therein, samples are to be drawn in presence of the magistrate and when samples drawn and certified by the magistrate in compliance with subsections 2 and 3 of section 52A the same would constitute primary evidence for the purpose of the trial. Full stop. The reason behind such provision is to inject fair play in the process of investigation Full stop. It has been held that Section 52A of the NDPS Act is a mandatory rule of evidence which requires the physical presence of a magistrate followed by an order facilitating his approval, either for certifying an inventory or for a photograph taken apart from list of samples drawn. Full stop. It has been observed that the provisions of the NDPS Act are both stringent and rigorous, and therefore, the burden heavily lies on the prosecution. Full stop. Non-production of a physical evidence would lead to a negative inference within the meaning of Section 114G of the Indian Evidence Act. Full stop. In the case in hand, though the inventory prepared in compliance of the procedure set forth in Section 52A NDPS Act was exhibited as Exhibit 7, the prosecution did not examine any photographs. Any exhibited? No. Any photographs, taken before the magistrate, in compliance of the provisions contained in subsection 2. Photographs taken before the magistrate and any list of samples, taken before the magistrate and certified as true by magistrates, during the course of the trial. Full stop. It has not emerged from the evidence stroke materials on record that the seized contraband items were disposed of at any time, at any subsequent time, by taking necessary permission from the magistrate in the manner envisaged in section 52A of the NDPS Act. Full stop. It was incumbent for the prosecution to produce and exhibit the entire quantities of seized contraband, as mentioned in the seizure list, EXT2, which were allegedly seized from the possession of the accused in the trial. Full stop. In the absence of, even if the physical evidence of the seized contraband were not produced, it was incumbent on the part of the prosecution to produce and exhibit the photographs and the list of samples taken before the magistrate and certified by the magistrate during the course of the trial. Full stop. Non-production of these such documentary evidence had clearly given rise to a situation for drawing a negative inference within the meaning of section 114G of the Evidence Act. Full stop. Para. Coming to the matters of search, recovery and recovery, we find that the NDPS Act 1985 has envisaged a procedure in section 42 thereof identifying the officers of the central government or the state government, as the case may be, who having a reason to believe from personal knowledge or receiving an information given by any person A, B, C, D. A, B, C, D. D Bishop. As per the by complying with the procedure laid down therein. Full stop. In the case in hand, comma, no such search and recovery of the allegedly seized contraband items were made by any officer empowered under section 42 of the NDPS Act 1985. Full stop. As has been indicated already here in above, comma, it was the villagers, it was the villagers who had taken up the cudgel on the basis of their suspicion that the accused was carrying out illegal activities in contraband items from the precincts of her house, comma, entered into the house of the accused on the date of the incident and claimed that the contraband items, comma, found mentioned in seizure list EXT2 seizure list, comma, inside the house of the accused. Full stop. Section 51. Of the NDPS Act 1985 has prescribed that the provisions of the Code of Criminal Procedure 1973 CRPC Code, Code of Criminal Procedure 1973 shall apply, comma, insofar as they are not inconsistent with the provisions of the NDPS Act 1985, comma, inter alia to searches and seizures made under the NDPS Act 1985. Full stop. As no specific procedure for search is mentioned in the NDPS Act 1985, comma, it is the procedure laid down in section 105 of the code, comma, more particularly, comma, subsection 4 and subsection 5 thereto would be applicable. Post up. As per subsection 4 of section 105, comma, लिखी दीजिए 100, I'm sorry, 105 number. As per subsection 5 of section 100, perhaps लिखी दीजिए. Subsection 6 of section 100 CRPC has mentioned that the occupant of the place searched has inter alia. এই দুটাতে ওলাইছিল যে ব্ৰেকআপ ওলাইছিল এগুলো কি নাকি? হ্যাঁ বল বিশৃংখল এইটো কিবা এটা আছে নেকি? এইটো কিবা আছে নেকি ইয়াতে? Source of a house. I went in. The Honorable Supreme Court in State of Punjab versus Balbir Singh, reported in 1994 3 SCC 299, has observed that entirely observed that the provisions of arrest, warrant, search and seizure are incorporated in sections 40 to 41, 70 to 81, 93 to 105 and 165 CRPC. Post of the Honorable, it has been noticed that the NDPS Act is not a complete code incorporating all the provisions relating to search, seizure or arrest, etc. It has been noticed that after incorporating the broad principles regarding search, seizure or arrest, etc., in sections 41, 42, 43 and 49, the Act, NDPS Act 1985 has laid down in section 51 that the provisions of CRPC shall apply insofar as they are not inconsistent with the provisions of the NDPS Act to all warrants issued, arrests, searches and seizures made under that Act. Therefore, the provisions of section 100 and 165 is also CRPC, CRPC, which are not inconsistent with the provisions of the NDPS Act, are applicable for effecting search, seizure or arrest under the NDPS Act also. It has been observed that the words, quote, insofar as they are not inconsistent with the provisions of this Act, unquote, in section 51 of the NDPS Act are significant. Full stop. Reference was made also to section 4 of the CRPC 1973, which has provided that all offences under any other law shall be investigated and inquired as mentioned therein. It has been held that consequently the provisions of the CRPC shall be applicable insofar as they are not inconsistent with the NDPS Act to all warrants, searches, seizures, and arrests made under the Act. If the officer happens to be one of those empowered officers under the NDPS Act also, then he must follow thereafter the provisions of the NDPS Act and continue the investigation as provided therein. If on the other hand, he is not empowered, then the obvious thing he should do is that he must inform the empowered officer under the NDPS Act, who should thereafter proceed from the stage in accordance with the provisions of the NDPS Act. One 65 to be. Your position, at this juncture, we may also dispose of one of the contentions that a failure to comply with last sign কি আছে কৈ পেলাই প্ৰেজুডিচটো কৈ দিম হা It has been held that non-compliance of these provisions, non-compliance of the provisions contained in section 100 CRPC would amount to an irregularity, and the effect of the same on the main case depends upon the facts and circumstances of each case. Full stop. In such a situation, the court has to consider whether any prejudice has been caused to the accused and also examine the evidence in respect of sirs in the light of the fact that these provisions have not been complied with, and further consider whether the weight of evidence is in any manner affected because of non-compliance. Full stop. Para. It is settled that as a person, as an accused, found guilty of the an offense involving commercial quantity of any contraband, is visited with serious consequences, the there has to be strict compliance of the procedure. Full stop. In an investigation involving contraband substance, quote unquote source, recovery and possession, possession and seizure are vital parts and and strict compliance are necessary to ensure that a person is not falsely implicated. Full stop. search being an integral part of the investigation under the NDPS Act and is meant to get evidence of the offense. Comma, an accused is entitled to the safeguards envisaged in the NDPS Act and the code. Full stop. If the safeguards are not followed, the logical consequence would be that the search would not have the same credibility which a search should have. Full stop. Reverting to the facts of the case in hand, comma, a large number of villagers, comma, on the date of the incident, went to the house of the accused and entered into the house of the accused comma, notwithstanding protest or otherwise from the accused, from accused or any members, any inmates of the house. Full stop. At the full stop. After entering into the house, comma, the villagers which comprise of about 10 to 12 women carried out searches and claimed to have found the alleged contraband substances. Full stop. At that relevant point of time, comma, no responsible village functionary, neither any responsible village functionary nor any police personnel was present. Full stop. If such a manner of search is allowed to be carried out for recovery of any suspected contraband substance by a large number of persons in a private residence of any person on the premise that there was suspicion that the person was in possession of suspected contraband substance, comma, there would also arise a possibility of planting contraband substance inside such house to foist the liability upon such person. Full stop. And no safeguards contemplated in the NDPS Act and read with section 100 CRPC would be available to such a person. Full stop. As the villagers had already suspected that the accused was carrying out illegal activities with regard to contraband substance in the house and had made an opinion that it had disturbed the atmosphere in the village, the villagers, including the persons who made the searches, cannot be said to be in the category of independent witnesses insofar as insofar as the accused in the case in hand is concerned. Full stop. In the light of the discussion made above, and for the reasons assigned herein, including non-compliance, including non-presentation of the primary evidence, as required under section 52A, and regarding irregularities in the matter of search to the prejudice of the accused, we are of the unhesitant view that the judgment and order of conviction and sentence passed against the accused cannot stand the scrutiny of law. Full stop. And the accused is clearly entitled to the benefit of doubt. Full stop. In such view of the matter, the judgment and order of conviction and sentence dated so and so, passed by the learned special court in so and so, stands set aside. Full stop. Already bailot আছে. Already bailot আছে. Bail bond stand discharged or what? As the as the accused appellant is already on bail, the bail bond stands discharged. In connection with any other case pending?
But, no, my lord.
No pending.
No pending. My lord, NDPS case number 24 of 19. Maybe
লিখে দিব হয়তো। But don't expect the order today.
Yes, my lord, no problem. She is already bail, my lord, maybe 7 days.
Yes. It's here. The case records of so and so case number be sent back for it. আমার সিরিয়াল পেছনে এলটিআর বলা লাগে পিসিআর মরি দিব না মরি দিব পেপার বুকখন I to lock নহয় মই একটু কিবা এটা জাজমেন্ট আছিল নহয় জাজমেন্টটো কৈছিলো ন কোট কৰিছো ন চাই ল'ব তাতে আণ্ডাৰলাইন কৰা আছে বাকী এটা নালাগে আৰু ন একটু Baldev Singh to. IA is disposed of already.
Yes, madam. Earlier disposal. Yes.
Yes.
Made, please. Worship, the on 21/10/2012, 22, the district and Session Judge South Salmara Manikasar has issued advertisement by which as many as 3 numbers of post of process server have been advertised. And out of the 3 post, my lord, 1 post unreserved, 1 post for MOBC, OBC, and 1 post for EWS. Pursuant to these advertisement, the present petitioner along with others have applied. The present petitioner belongs to EWS category. And thereafter, the written test was conducted on 8/1/2023. Advertisement is at page 25.
8/1/2023.
8/1/2023, written test was conducted. And after the written test, my lord, the list of qualified candidates have been published, which is at page 37. And total, my lord, 16 candidates. Unreserved category for 6 candidates. And OBC, MOBC 5 and EWS 5. The writ petitioners roll number, my lord, PS 0085. And the respond number 5.
This is for Viva Bhosi.
Yes, my lord, after the written test, the qualified candidates' name have been published for Viva Bhosi test. Herein, my lord, the respond number 5's roll number has been reflected in unreserved category.
What is the number?
Number PS 0194. And the petitioners PS 0085 EWS category. Then Viva Bhosi test conducted on 18/2/2024. After Viva Bhosi, the final select list have been published. This impugned, my lord, page 39. In this list, the present petitioner name has been kept in waiting list. And the respond number 5 has been selected as EWS category candidate. In fact, initially her name reflected under unreserved category. And along with this impugned list, my lord, the compiled mark sheet, that is page 41. The marks of the present petitioner, serial number 5.
Shading 58.
Serial number 5, he got 59.5 total marks. And the respond number 5 at serial number 8.
Maybe horizontal reservation.
Yes. Horizontal reservation.
Might be. Well, you should notice at this stage. If she is entitled for horizontal, then you will be definitely replaced.
That's correct.
That possibility is there.
But in single post in every
Whether
category.
any other male, any female?
No.
Joles Sabir Amin and Joleswar. Both are male.
Yes.
So possibility of women reservation,
And
horizontal,
other things, well,
cannot be ruled out.
I have already alleged that regarding the EWS certificate is concerned, because earlier her name reflected under unreserved category, and I have filed in RTI.
You have a ground to challenge.
Yes, ma'am.
Okay. Yes, we will issue this. Heard. Mr. R. Islam, Learned Counsel for the petitioner, and Mr. H.K. Das, Learned Standing Counsel, Guwahati High Court.
2, 3, respond number 2 and 3.
For the respondent number 2
and 3.
And 3, my lord.
and 3. Also heard MS. Your name, please. You Sharma, learned junior government advocate for the respondent number 1 and 4. Full stop. Para. By publication of an advertisement dated 21/10/2022 within bracket annexer 1, comma, the office of the respondent number 3 invited applications for the following vacancies in the post of process server in the establishment of the respondent number 3. Colon S query page 25 or table quantity table table my in response to the advertisement dated 21/10/2022, comma, the petitioner submitted his candidature for the post of process server in the EWS category. Full stop. After scrutiny of applications, comma, the petitioner was issued an admit card with roll number PS 0-0085 to appear in a written admit card annexer 3 in a written examination, comma, scheduled to be held on 8/1/2023. Full stop. According to the petitioner, comma, the respondent number 5 submitted her application under the unreserved category, and the respondent 5 was allotted roll number colon PS -0194. Full stop. After the written examination, comma, the respondent number 3 published a notification dated 1/2024, annexer 4, declaring the results as under table on the page 37. Para. The candidates whose roll numbers appeared in the notification dated 1/4/2024, comma, were called to appear in a viva voce and after completion of the selection process, comma, the respondent number 3 published the names of the candidates in a select list along with a waiting list by the notification dated 4/6/2024 within bracket annexer 5 as under দুখন table আছে. Para. Mr. Islam Learned Counsel for the petition has submitted that the petitioner secured total marks of 59.5 in the selection process, whereas The respondent number 5 secured a total marks of 58, comma, as discernible from the compiled mark sheet, comma, annexed as Annex 6. Full stop. It has been contended that the respondent number 5 had applied only in the unreserved category, and his application was not processed under EWS category, comma, as discernible from the notification dated 4/6/2000, as discernible from the notification dated 1/2/2024, Annex 4. Full stop. But the respondent authorities, while publishing the select list, had illegally included the name of the respondent number 5 in the select list under EWS stroke Omen category. Full stop. The petitioner has prepared a writ petition on the ground that since petitioner applied under the for the vacancy reserved for vacancy of process server reserved for EWS category and had secured more marks than the respondent number 5, comma, the respondent number 5 could not have been selected under the EWS stroke Omen category. Full stop. Issue notice. No matter would require further examination, issue notice returnable on 4 weeks of duty.
Well, wait.
As Mr. M.S. Sharma, learned government advocate, junior government has appeared and accepted notice on behalf of the respondent number 1 and the respondent number 4. And Mr. Sharma, sorry, Das, learned standing counsel, GHC, has appeared and accepted notice on behalf of the respondent number 2 and 3. Issuance of formal notice to the said respondents as dispensed with. However, the learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with annexes to M.S. Sharma and Mr. Das within 3 working days from today. The petition shall take steps for service of notice upon the respondent number 5 by registered post with AD within 3 working days from today. Full stop. In view of the contentions raised in this writ petition, it is observed that the selection and appointment of the respondent number 3 would be subject to the outcome of the writ petition. Anything?
Five.
Five.
Respondent number 5.
Much.